So, friends, we are now moving forward to understanding an important part of contract requirement, uh, the essential, uh, test of an agreement to be enforceable as a contract. This is probably the final test, apart from what we have seen so far. That you have to have an offer, you have to have an acceptance, there has to be consideration, you have to have capacity. The consent ought to be free, but finally, and most importantly, that the object and consideration of the contract should be legal, right? This is the final test, right? So if the object of the contract is not legal, or if the consideration in the contract that flows between or exchanged between the parties is not legal, then the contract will not be enforceable, right? The agreement is not going to be enforceable at all. So this is the final essential element of making agreements as contracts. Now, when do you think there are possibilities that the legality will be tested in a contract? Now, we should understand that contract law is the basic law; it's a foundational law, and it's not a law that tells you which contracts are doable and which contracts are not doable. We probably have to understand the same with the help of other legislations. Let's take an instance of a legislation called the Indian Penal Code. Now, Indian Penal Code 1860 is the basic criminal law of the land, and it does prohibit certain kind of activities and makes it punishable or makes it a crime to probably attempt to commit someone's murder, right? Now, can there be a contract that is done? We say supari killing, right? Can there be a contract which says that if you go and kill I will pay you 1,000 rupees, right? Now, these kinds of contract, friends, you have to understand, is very, very important in terms of the legality of the object of the contract. What is the object of the contract? To cause injury or harm to another person or to another property. This may be forbidden by law, right? There are so many legislations that are complementarity, which say you can do this, you cannot do this. For example, dealing with banned substances or narcotic substances, or what we call as these banned drugs, as it were. Now, you have a legislation which clearly says that dealing with the same sale, transfer, transaction in any of these substances is prohibited by law, right? It is illegal to deal with those kind of stuffs in India. So any transaction that can deal with narcotic substance is forbidden by law. So you cannot have a contract. So the central object of the contract is something that is prohibited by another statute, and because it is prohibited by another statute, the legality of the object test is not going to be fulfilled, and hence the agreement is not going to be enforceable at law. What does this mean? This means that the parties cannot approach the court of law. The remedies for breach of contract are not to be granted by the court of law, and the parties may have to settle their own scores, beyond the legal system or beyond the law. So, important for us to understand what is permitted by law and what is forbidden by law. For example, we can also say, can there be a contract for the purchase of a kidney, right, blood, or human organs for that matter? Now, again, you will notice that we have legislations like the Transplantation of Human Organs Act and several other legislations which have said that, look, there cannot be any transaction for the purchase or sale of kidney or for blood. These are essential human organs that cannot be traded, they cannot be commodified, they cannot be commercialized, and hence no contract of that character or nature is permissible. The legality of object, right? Testing the object of the contract, whether the object is permissible by law or whether the object is non-permissible by law. I think that is something that we have to understand as the subject matter of the contract. For example, let's assume one more, kind of a, example to test the object of a contract. Now, very often than not, we have people trying to make several kinds of contracts, and it could be as normal as buying land. It could be as normal of selling, products, purchasing services. But again, if you focus on the object of the contract, friends, you will notice that a lot of times we have, control orders on certain kind of commodities, like the sugarcane control order, or the coffee control order, or the milk control order, which may be a control order which are there under the Essential Commodities Act. Or you will notice that probably during a pandemic or a health emergency time, certain drugs were listed as essential commodities. Certain vital, life-saving drugs were listed as essential commodities. Now, it is not that the law forbids you from dealing with it, but the law actually fixes the price at which it should be transacted. So there could be a law that clearly gives you a prohibition from dealing with it. There could be another law which says you can transact but at a specified price. There could be another law which says that you should only sell it to the government and nobody else. Right? Now, for example, we under the sugarcane control order, which was there, prior to the LPG era, and it existed even later on for some time, which is the liberalization, privatization, and globalization era. You would notice that the farmers or the cane growers had to sell their cane to only a particular factory and through government regulation and order. So there is a forbiddenness to the freedom of contract, right? You don't have an absolute freedom. Sometimes it is restricted. So your object of the contract should not be against a given law. So whatever the law prescribes, you can only work within that. You can make contracts within that. Anything that is forbidden by any other statute apart from the Indian Contract Act, if you attempt to do it, it will touch Section 23 of the Indian Contract Act. And because it violates Section 23 of the Indian Contract Act, the contract will be held to be void. Now, there are two things that at this context one must realize. And that is void versus illegal, right? Now, void means it has only civil consequences or a civil action or a sanction. Whereas what is illegal, friends, is something that is clearly forbidden by law. It would probably say like this in the IPC that any contract to kill someone is punishable with an offense of 6 months. It is not only forbidden, but it is also punishable by a given statute. If you decide to make a contract which is then attracting forbidden law with an additional amount of punishment that is prescribed by that special statute, then we would say that the contract is illegal. Right? So illegal contracts are, interestingly, friends, have no remedy whatsoever in the Indian Contract Act. Void agreements still have some remedy, but illegal contracts are not. So illegal contracts are treated far more stringently. They are prohibited, forbidden, plus there is a punishment in case you do anything that is in furtherance of the same through a contract that you would probably do, right? Also, Section 23 very interestingly has what is known as the direct test and the indirect test. Now, the direct test is that, look, if you make a contract that is forbidden by law, then obviously, that's void. However, there are so many legislations that may not give a clear prescription that please don't make a contract regarding this. They may not say so. But what you make in your contract defeats the provisions of those laws, the object of those laws, the vision of those laws. And hence, this is the indirect test. So, if your contract attempts to defeat the provision of any given statute, right, indirectly, even then, please note that agreement is not going to be made enforceable. It would attract Section 23 and it will be declared as void. So this is the first two is one is the direct test, the second is the indirect test. So I think respecting parliamentary intention of the legislature, the Indian contract law, though it's a foundational law, is always balanced with the interest of legislations that are made later on. And any such legislations can actually make prescriptions of which kind of contract is permissible, how it should be made, and if it is not made as per those special legislations, then it would attract Section 23. Section 23 of the Indian Contract Act also insists on the fact that contracts that are made between two private individuals cannot attempt to injure any other third individual to either himself or to the property of that person. Now, contracts are supposed to benefit two parties, the seller or the buyer, as the case may be, or maybe in case of government contracts, it is to benefit the larger public, as we say, public works contract, right? So you don't expect contracts to, in any attempt. So the object of the contract must not result in making a kind of attempt to injure a person or a property. So this is also an interesting element under Section 23. It opens up a kind of an area that is not necessarily to be decided by any other legislation. This is something that courts can also intervene to decide, right? So if two persons make a contract wherein the element of this contract is promising or attempting to promise any kind of loss, injury to the person or the property of another individual, then to that extent those contracts could be held to be void, right? This very clearly gives the direction that two brothers cannot fight amongst themselves so as to cause injury to some third party, or two brothers cannot enter into a contract wherein they decide to share the property between themselves but deny that property to their third brother, right? So injury here is not the injury in the sense of the physical term. It is injurious to the right interest of the third party, right? That is where the element of injury definitely comes into place. So say in a government contractual sense, this injury could be to a competitor, right? Where you want to exclude the competitors and you include certain aspects. So you actually have a tacit understanding between the contractors, and then say, look, we'll try and exclude the competitors so that they don't get business. Injurious, right, to person, property, business. That I think is a very interesting way in which Section 23 has been crafted, and that's why I told you in the past, friends, that Section 23 is the heart and soul of contract law. It very clearly expects contracts to be for public interest, public welfare. It can result in profit to the contracting parties, but then there is a public element. That public element is your contract should not affect public interest, public rights, right? That's, I think, a very interesting part of the Indian Contract Act. It's an interesting scenario in the Indian Contract Act. And also, please note, there is this concept of public policy that has been brought under Section 23. Section 23 says that agreements that are injurious to public policy. Now, this is interesting. The definition of public policy does not exist. It's not there. It is for probably the judges to evolve and decide. Because, again, if you go back to my previous point, there are certain things that cannot be static. It cannot be permanent. It has to evolve from time to time, right? Now, for example, why there is no definition of a public policy? I think because the drafters of the Indian Contract Act wanted to keep this as an open question for application, for evolution. Every generation would want to determine its own public policy, right? Public policy in government contract can be something else, and in a private contract it can be something else. So you cannot have one precise definition of what it means. Some judges have attempted to define it by saying public policy could mean injury to public interest. Yes, it can be. Say public policy could mean avoiding paying the appropriate stamp duty or registration charge in a contract. That can also be public policy. So if there is an agreement between two parties which is going to be injurious, please note, the injury need not occur, right? If the injury occurs, let me tell you, it can amount to a crime, right? So injury to person, isn't it a crime? Yes, the Indian Penal Code says it is a crime. Injury to someone's property, isn't it a crime? Yes, it is a crime. So if you actually commit the act of doing that injury to person, property, or public policy or public property, then you will be punished under the criminal law. That's a different issue. But an agreement to that effect is not permitted, right? This is one. Point two is that agreement is a consent to defeat the object of any legislation, and that's where you notice that these 4 points become a very critical factor in deciding whether agreements are going to be enforceable at law or whether they're not going to be enforceable as well. In the next slide, we will deal more on public policy, especially in the current context. I'll give you some very recent and very classic examples of how and where this public policy element has to be brought into place in terms of the discussion on contractual issues. The fifth point that Section 23 deals, and I think is a very important way in which Section 23 evolves, is contracts that are immoral. The object of the contract, if it's immoral, or if the consideration in the contract that flows is immoral, then the contract is void as well. So I think Section 23 is so encompassing. It has so many elements of determining the legality of object. Immorality, right? Very interesting point. What is moral and what is immoral? How does one test it, right? There is nothing like a parameter of definition that the Indian contract law gives. However, you will notice again that morals are some kind of preachings, guides, the do's that spiritual and religious institutions actually give in a given society. Our parents, our teachers can actually guide us about what is moral and what is immoral. Morals are, I think, high standards of human behavior, expected standards of human behavior, right? And if you fall, the natural statement is that probably you are immoral, right? Now, the expected standards of human behavior, friends, you will notice, are generally laid down in our day-to-day activities, right? Our elders tell us what to do, what to not to do. Religious leaders will tell us. Our spiritual texts will tell us what is moral and what is immoral. Now, this element in contract also says that, look, what is there in society as high standards of human behavior is also expected in your commercial transaction, in your commercial contracts. So being immoral is an element that is not permissible in contracts. So the object of the contract cannot be so. The immediate question for many of you should be, sir, how can you give us some illustration or examples on immorality? Friends, we can give you a lot of examples on that, and please note, these examples do exist from time immemorial. Let's look at some traditional categorizations, right? Now, in traditional categorizations, you will notice that there was this concept of a concubine in certain societies in India, mistresses in certain societies in India. Now, let's assume, friends, that I have a concubine or a mistress, and my society permits me to have the same, right? Now, you must be saying, sir, which society do you live in, right? In today's society, friends, you will notice if you are a Hindu, you're governed by the Hindu Marriage Act. If you are a Muslim, you're governed by the Muslim Marriage Act or the Christian Marriage Act, as the case may be. We have special legislations. However, in India, most legislations, except the Muslim or the Mohammedan legislation, insist that you must practice monogamy, right? You must have only one spouse at a time, right? Unless it is divorced and so on and so forth. So monogamous marriages are something that is facilitated by a given law. Now, can I have a concubine, right? In or maybe before 1955, friends. The time why I say about 1955 is because that is the time the Hindu Marriage Act was brought into place and monogamy became a rule. But before 1955, during British times, in West Bengal, in certain societies in India, these kind of, polygamous marriages. Now, polygamy, please note, is also something that the Indian Penal Code speaks about. But polygamous marriages were some kind of permitted in certain circumstances. And this concubine issue is a very important issue because it has some customary traditional connotations, right? Suppose, just imagine during those times, concubine was permitted, right? The Devdasi system was there, and so on and so forth. So I can give you numerous examples how the Indian society had some of these practices and systems. Now let's imagine that my concubine or my mistress has to get maintenance, right? It's my duty to maintain my spouse, isn't it? That's what the law says. Isn't that what morality would want to say? Moral high ground, right? I must maintain my dependence. Now, I make a promise to a concubine. Please don't. It's a promise. It's an offer. Saying that, look, if you remain loyal to me, and you should do that, I will give you a house and I will give you a maintenance of 5,000 rupees every month. I make this promise. The concubine accepts this promise, right? Now, this kind of a contract can be tested on Section 23. You know why? Legality of object, morality of consideration. So, society may permit me to have a concubine. Can it allow a contractual promise to the concubine? Right? This is something that we will have to be testing because, please note, friends, the fact that I have a moral obligation to maintain someone is fine. I may have a legal obligation also to maintain my dependence is also fine. But the fact is, can I make a contract that is immoral? Morality here very clearly means that you are actually giving consideration or payment to something that society does not permit. Society thinks having a concubine is not moral. You must be dedicated only to your wife. Monogamous marriage should be respected. So societies will have to change, will have to evolve. And hence, friends, you will notice even morality is a changing dimension. It's a changing perception. What was moral in the 1980s probably may not be moral today as we speak right now. Right? Societal values may change. The younger generation may take morality as some kind of, absurd kind of a standard. Who is society to judge whether I'm moral or not? Why should the society judge the same? Remember, the thin line of distinction is I say this is moral, right? But does the law say it's illegal? Right? If it's illegal, obviously, whether it's young generation or older generation, you're not supposed to practice the same. So any kind of a contract that is illegal, obviously, is not to be permitted by law. But morality is not what the law prescribes the illegality. It is about your expectation of high standards, right? And remember, when I say your expectation of high standards, it could be something that the judges in a case may want to implement or judge. Right? So the judge may say this is immoral. So the statutes, remember, friends, section 23 says if an agreement is immoral, it is void. Yes. So the testing is going to be by the judge on whether what is the object of this contract is moral. I'll give you one more example. Let's assume, friends, that you are a landlord of a house and a gay couple or a homosexual couple want to take rent of this house. They want to become your tenants. Let's test this. Hypothetically, what do you think? This is moral or immoral? Now you may be saying, sir, is being gay legal? I'm not sure. The Supreme Court right now has said, as we speak today, has said that being homosexual is not a crime. Right? But it has not said being homosexual is legal. Right? This is one part of the story. But do you think our society is yet to accept homosexuality as moral? This is for us to decide. Now, I'll tell you a precise, kind of an example that I always, kind of go for empirical evidence. If you go and speak to elder generations, I'm talking of the 60s and the 70 years old, they will tell you homosexuality is definitely not moral. You take a survey, majority will tell you it's not moral. But the younger generation, if you go and speak to a 20, 25-year-old, they will say it is moral. There is a generational gap on the morality of homosexuality. But the point is, friends, let's talk about the contract of giving tenancy. You are a landlord. Will you give on rent a house to a homosexual couple? You may say, why not? What is the immorality there? Immorality is, friends, probably the society, like say in Haryana or in Uttar Pradesh, where they are very conservative societies, they may think that you are promoting homosexuality indirectly. You are promoting such kind of behavior indirectly. Friends, morality is an external element of what the society thinks you are. You may not care about the society, that's a different issue. But that is what the society as a majority would want to impose upon you. Right? Say, for example, in so many societies today, we are still grappling with intercaste marriages. Right? There are so many societies that do not permit, they think it's not moral. So I think the issue on morality is a very, very tricky issue. There are few cases in which it has already been implemented or decided. For example, I'll give you one very classic case in which immorality was judged. A carriage, right? It is like giving a car on rent. Let's imagine, right? The owner of the car or the owner of the carriage gave it to a prostitute. Yeah. He gave it on hire. He gave it to a prostitute. And she took that carriage for her sex workers we call them, right? So she went in the evening in that same carriage, she performed her work, and then she came back and she returned the carriage. The issue is she refused to pay for the hire of that carriage or the car. She was very clever, right? She said, I won't pay it. You know why? Because you have given the same for an immoral activity. The court had to judge whether this contract, giving the carriage to a prostitute or a sex worker to do her own trade, is it moral or immoral? Now you judge this. I would say, most of you will say it is immoral. Prostitution is immoral. Sex work is immoral. Friends, you are judging someone else. You are judging that sex worker. The society is saying that is immoral, right? And hence a contract of carriage for prostitution is going to be immoral. Similarly, can you give your house on rent to a prostitute or to prostitution or to a sex worker? Can you? Should you? See, please note, there is a law which probably would regulate these activities because that house could be used for the purpose of prostitution, right? So you don't expect, see, prostitutions have the right to shelter. I don't deny that. It's a human right. But the contract on morality is something that we all have to test and we all have to determine, isn't it? And having it in law, it's kind of, what the Britishers thought. 1872 is this law. The Britishers wanted to probably put in, the aspects of morality. Now, I don't know when the Britishers brought this law, whether they were testing morality as per Christian standards and British standards, because the judges were all British during that time. And here are Indian who are practicing certain very interesting aspects of, what this contract is, what this custom is, right? Okay, so the point is, you can't stretch morality to other elements. This is something, luckily, the Supreme Court has restricted morality. They have said, we are not testing morality on other aspects. For example, it could be animal cruelty, right? What could be animal cruelty, friends? We put a kind of a metal piece to the leg of a cattle, so that when the cattle is actually galloping and running on our roads, they get grip. Right? Suppose I give a contract to a person to put that half horseshoe shaped metal piece to the leg of a cow or a bullock. You may say, sir, that is cruelty to animal, it's immoral. But remember, immorality on several other grounds cannot be done under contract law. The Supreme Court has said, let us only restrict morality to sexual morality. Yes. So morality is only on sexual part, and that's the narrowing down of this definition under Section 23. But remember, the examples that I gave you on homosexuality, on prostitution, on concubines are all those aspects that determine sexual morality. And any such contract could be set aside by the court of law on the ground that the object of the contract is immoral. Second, the consideration of the contract is moral. Now you must be saying, sir, how can consideration of the contract be moral? Very simple, friends. Suppose I am going to build a house. Okay? I am going to build a house. The money that I get to build this house, the consideration that is coming to me to build this house, should it be legal or can it be illegal? Now, what is illegal money? Friends, let's assume that this money is coming through the Hawala transactions. Illegal money. Violation of FEMA regulations, Foreign Exchange Management Act. It has been smuggled into India. The money is, wrongly printed. In those circumstances, would you say that that consideration is legal? No, you will not say it is consideration is legal. Similarly, moral. Let's assume the money that is given to me to construct this house is coming from, say, the earning that a prostitute or a sex worker has done. Is that consideration legal? That money has to be utilized. I completely agree with you. But can I make a living on what the sex worker has contributed to me? Maybe the judges in this case would say that the consideration is immoral, right? Moral money. What is it? You do the hard work, you take the income from it, you construct your house. That is moral. That is what our spiritual leaders, advisors, gurus, our religious texts, what is there as society? Society will say only utilize good money, white money. But black money, immoral, illegal, both. Prostitution, who is earning her own income, is it immoral as well as illegal? Right? So I think when it is immoral and illegal, it's very easy to decide, friends. Right? There is no problem because the law actually puts that prescription. But remove that legality part, just focus on the immorality part, then you will start finding how difficult it is for judges to actually decide those cases in which the consideration is considered to be immoral. Right? And those, I think, are aspects that one will have to consider. For example, I'll just give you the last instance of immorality of consideration. Money that is coming from bribe. Yeah. Can it contribute to a contract? Should it contribute to a contract? I'm sure your answer will be a definite no. Right? That is a consideration that we can always say is an immoral consideration. So we will understand Section 23 with various of its facets, in which one of the other issue under what we would want to look at, the traditional categorization of trying to test the legality of object. Now, there are two categorization. One is modern categorization of testing legality, and one is traditional categorization. Now, in traditional categorization, you will notice that trading with enemy is considered to be violating, uh, the aspects of public policy, right? Public policy means public interest, public welfare, country's priority, and hence, if the country is at war with another state, it could be the neighboring states or countries or any other state on which the country imposes what we would want to say as the enemy status. Then, in those circumstances, trading with such kind of enemy state or its citizen is considered against public policy, right? So there are two things that you have to understand over here is that the legality of the object can creep into the contract at some point of time, maybe at the stage of performance, maybe at the stage of delivery of the goods, maybe at the stage of receiving the goods, maybe at the stage of paying the price or paying the consideration of the contract. It could be at the stage when the contract is also entered into, right? Now, you cannot probably go against a national security interest. So contracts are expected to adhere to those national security interests, and that's what public policy is, obviously. So citizens who are making a contract cannot contract with an enemy state and its citizens, and this is very clearly prohibited. That is considered against public policy, and hence the legality of the test of the object and consideration in such contracts is definitely tested on those grounds. Uh, Trafficking in public offices, which means that you cannot use illegal, unethical, immoral means to gain access to public offices or favors, grants, contracts for public offices. Now, we know that in government contracting, there is a very interesting pact called the Integrity Pact. This is something that both the government and the contractors have to enter into, right? The Integrity Pact is generally the anti-corruption kind of a clause. Both the parties say that they have approached the contract with clean hands without actually trafficking in public offices. They have not offered any kind of unethical or immoral or illegal gratification to actually seek the contract. And hence, trafficking in public offices is a prohibited activity, it's a punishable offense. Further, any contract that actually tries to look at trafficking of public offices is attracting Section 23. And such contracts will definitely be not only void, but I think it would be illegal as well. So we have to understand that we always use this statement, all illegal contracts are void, right? However, all void contracts need not be illegal. The illegality of contract comes into place, especially if one evaluates the fact that the action that leads to the voidness is a punishable activity. It has been held to be prohibited, a punishable, with sanctions, with imprisonment, with fine. And that is where you will notice that the illegality of contract is on a separate footing. So all illegal contracts are void. All void agreements need not be illegal agreements, right? Like we talk about trafficking in public offices, you should also look at interference with the administration of justice, right? Now, justice administration is the judicial system approaching the judge, trying to make contracts, trying to do backdoor deals to secure settlements and judgments. All of these are prohibited activities, and they are something that the law does not provide for, and hence it's a clear example of how the object of such contracts are not to be encouraged. These contracts cannot come into existence. Anything that you do with justice and justice administration, the contracts are going to be illegal as well as void, right? So you can't get into any of these actions, and these actions are considered to be clearly prohibited actions of contract. Finally, friends, marriage brokerage agreements were considered to be immoral at one point of time. Why? Because marriage was considered to be a kind of a sacred activity. It was supposed to be a noble religious activity for which contracts that actually try to make the boy and the girl meet or try to brokerage the marriage were not considered to be moral. They were considered not to be enforceable at law. This was during early times, but now times have changed. As I told you, morality, marriage, things are in a different dimension today altogether, and hence I think the dimensions of early times need not be the dimensions that we today do it today. So these are some traditional categorizations under Section 23, and they give us an idea about how. And please note, the interesting part of Section 23 is somewhere you'll notice at the last line of the section, as it is written by the British lawyers, draftsmen, they have given the right to the court to determine two things: the issues on public policy and the issues of morality. This is something that is always dynamic, it is not static, it could change. Who are the parties, what is the subject matter of the contract, and hence the courts will decide whether it is in favor of public policy or is opposed to public policy. So the role of the court in Section 23 is quite wide, very, very important. And that is where you will notice that there are a lot of judicial verdicts over here. There are interesting cases that come by over here. And don't forget, government contracts are also tested on the ground of Section 23. So if you just go by a very interesting case, and the case name is Brojanath Ganguly versus Central Inland Transport Company. It is the case of precedent under Section 23. Central Inland Water Transport Company was a government company which had an employment contract, and the terms and conditions of the employment contract were challenged as being opposed to public policy. Please note, contracts are also between an employer and employee. It can be a tendering contract, it can be some other outsourcing contract. So everything that is done by the government. Interestingly, there are two legislations that actually converge. One is the Indian Contract Act, other is the Indian Constitution. So Article 14 of the Indian Constitution very clearly states that any action of the government which is arbitrary, unfair, unreasonable is something that the courts can strike it down. And be it the contractual one, right? Contracts can be challenged as being arbitrary, as being unreasonable, as being unfair, as being discriminatory of the policy of equality. And hence in Brojanath Ganguly versus Central Inland Transport Company, you will notice that the Supreme Court states that anything that is unreasonable in an employment contract is liable to be struck down. It is liable to be moderated. And governments don't have the discretion to make contracts that are unfair and exploitative. And public policy very clearly means that the government contract has to be in favor of the public spirit, in favor of public interest. And if the government fails to draft a contract in public policy, then such contracts are liable to be struck down. So that's the Supreme Court decision that has always been cited to actually challenge government contracts on the ground of public policy.